reporter. And let's see. Interpreter. Thank you. It's been a long morning,
And
Mr.
the court reporter needs to be sworn in, though. They need to be accurate.
You're right. So Mr. Sprouse was just here a minute ago, or is Ms. Gaynor?
It's going to be Mr. Sprouse's case, Your Honor, but I am covering the pretrial detention hearing for today.
Oh, okay. So Ms. Gaynor is present for the state, and we do have an interpreter present. The defendant is present. And state?
Your Honor, I believe that the defense will be requesting this court for...
Oh.
Yeah, we're going to be making a request for a continuance, Your Honor. There's some documents that we need to get our hands on before we can effectively represent the client. And the clerks, the issues with the clerk site is part of the issue. There's actually a co-defendant that we're trying to get the report of that co-defendant. I can't access it because the case hasn't docketed yet. So that's an issue. That's a legitimate reason, I think, for a good faith motion to continue. So we're asking the court to continue it. The state's told me, I'm sorry if I'm talking too fast. The state's told me that their officers might not be available next week, but maybe the week after. So in all likelihood, it'll be a 2-week continuance, and I haven't had a chance to tell my client that, but I want to make sure he's okay with that.
I can put the white noise on to give you a little privacy.
I'm not worried about that. I don't think it's an issue regarding privacy. I appreciate that, though.
Okay.
So I'm just going to tell you up here, I'll just, I think we're going to need more time to prepare. My understanding is that he does agree to the 2-week continuance, understanding the state. I think the representation is that their officers are unavailable because of training, and if they do in fact represent that, that would be a good faith basis for them to basically continue it for the second week, I guess is how we do it, or we'd stipulate to that.
Okay.
That is correct, Your Honor. Next week, Mr. Ocala and I both actually talked to the officers in the back of the courtroom before we left for lunch. They did represent, they will be actually, I think it's Nashville, they said, for training. They're essential witnesses. It's the lead investigator and lead deputy on the case. So the state would ask if it were to be set next week for continuance to the July 3rd date. I have no objection to the continuance today, and we'll be ready to go on July 3rd with subpoenas out for those two officers.
Okay.
And in the interim, I just asked the state to forward us any discovery, any documents, any witness statements, video, anything, in fact, in the case, if possible. I just
Okay.
just checking that date.
Yes, go ahead and check for July 3rd at 12:30.
That should be fine as long as my partner doesn't get appointed to the bench. So it should be okay.
All right. So we will continue the hearing based on the agreement between the state and the defense to July 3rd at 12:30.
Very good, Your Honor. That's all I have.
Thank you.
Thank you.
I'll see you on July 3rd.
All right, very good. I know. Can I talk to him? Thank you.
And I've entered an order to that effect.
Your Honor, this is Salvador, oh, sorry.
Go ahead.
Okay. Salvador Castro Martinez, 25 CF 1165. Also here for a pretrial detention hearing.
All right, is the state ready to proceed?
State's ready, Your Honor. Cody Sprouse on behalf.
All right, thank you, and
I'll just have my client sit at the table with us.
yes, and do we have the interpreter present?
No, we don't need the interpreter.
Oh.
I've spoken with Mr. Castro Martinez before, and he has said that he does not need the interpreter.
Okay, sir, we will provide an interpreter if you need one. Are you okay without an interpreter?
Okay. Okay.
Okay.
I will, of course, pause and request an interpreter at any point if we need one.
Please do, and we will provide one. All right, the state did file a motion for pretrial detention, and this hearing has been continued from last week. And whenever the state is ready to proceed, go ahead.
Thank you, Your Honor.
Thank you.
The state would first like to call Officer Tyler Williams.
Okay.
Get up here, turn face, judge, first swear you in, please make sure you speak clearly into the microphone.
Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. Just have a seat right there.
Good afternoon, officer. How are you today?
I'm good, sir. How are you doing?
Doing great. Thank you for coming in today. Could you please state your full name for the record?
My name is Tyler James Williams.
Where are you employed?
I'm employed by the Fort Walton Beach Police Department.
And how so are you employed?
I'm sorry?
Are you a officer?
Yes, sir. I'm a full-time police officer with the city of Fort Walton Beach.
For how long?
Approximately 3 years now.
Okay.
A little over 3 years.
Do you remember if you were on duty on June 8th, 2025?
Yes, sir, I was.
Did you get a call from a church
Yes, sir.
in Fort Walton Beach?
Yes, sir.
Or Mariester?
It was Fort Walton Beach.
Okay. What was that call?
The information that we were provided was that there was a male in a disturbance, and one of the call notes was that the male pointed a gun at children, what looked to be a rifle.
Okay. And what happened next?
Obviously, officers, expedited their response, did an emergency response. Upon my arrival on scene, Corporal Mooney and Officer Holland were already on scene. Once I got there, I plussed them up, and we began to move forward to where the defendant was laid out next to his vehicle.
Forgive me, what is plussed them up?
Essentially, the three of us moved up together to the vehicle, moved from behind cover of our vehicles to place the defendant in handcuffs.
Okay, what actions was the defendant doing at that time?
Upon my arrival, he was out of his pickup truck, and he was lying on the ground, face down, with his arms out to his side, similar to an airplane.
Okay. What happened next?
We moved up. I transitioned from lethal coverage with my agency-issued handgun to less lethal with my department-issued taser. As we moved up, we continued to give the defendant commands to stay where he was at. And then once we got up there, I placed him in handcuffs, assisted him to his feet, and then I began walking him to the back of my patrol car.
What did you locate in the vehicle?
There was what later was determined to be a BB gun that was located inside the vehicle.
Could you describe that BB gun?
I did not personally see it because I was standing by with the defendant at the rear of my patrol car.
Okay. Did the defendant make any statements to you?
He did. He was in an excited state. I attempted to get him to calm down, and after getting him in the rear of my car, I issued him his Miranda warning and, hey man, do you need any medical attention? Are you okay? He said he was okay. And he started kind of trying to explain what happened to me. What I gathered from it was that he went to the church and he sent a picture of the church to his children's mother to prove that he was at church. Like I said, he was kind of hard to understand just because he was in, like I said, an excited state. What I gathered from it was that he went inside, asked to speak to someone, said he needed some help. Someone eventually came out of the church, got into his truck, he said, without him inviting them in, got into his truck, they talked, and that's whenever the member of the church noticed what he believed to be a firearm. The defendant told me that he told him, hey, it's nothing to be scared of, we just use it for target practice. And then that's when the defendant said that the member exited his truck and then called the police.
Did anyone provide you with a description of the firearm? Or of the BB gun?
They said it was a rifle. They believed it to be a rifle, so I figured it would be a longer gun. But I would have to refer back to the call notes.
Okay. I have no more questions.
Defense?
Good afternoon, Officer Williams. How are you?
I'm good, ma'am. How are you doing?
I'm well, thank you. Excuse me. The gentleman that you mentioned who came out of the church and got into my client's car to speak with him.
Yes, ma'am.
Did you get that gentleman's name?
I did not because, like I said, I was with the defendant. We were kind of spread out there.
Yes.
So there were some officers that were with the vehicle and the children that were in the vehicle. And then there was another officer that was actually getting statements from witnesses and victims, if you will.
Okay, so was there a statement taken from that man? Do you know if there was a statement taken?
I couldn't tell you 100% with certainty. Like I said, I only had to go off of what the defendant told me.
That man was presumably the one who first raised the alarm about an alleged rifle, though.
Objection, speculation.
Sustained.
Do you know who made the call to the police, the first call to the police?
I would have to refer back to the call card.
Okay. And do you know if they made the call because they observed an alleged rifle or because they heard about it from someone else?
From my understanding was the caller observed him pointing what they believed to be a rifle at children.
Okay. But you at least didn't ever speak with the gentleman who had been in the truck speaking with my client?
No, ma'am, not me personally.
Sorry, let me just refer to my notes. Did my client ever make any statements about whether or not the BB gun was loaded?
I don't recall.
Okay.
I don't recall.
And did anyone else make any statements? I know that you didn't really speak with any of the other witnesses, but did you hear any statements as to whether or not the BB gun was loaded?
I don't recall hearing specifically if it was or was not loaded, no, ma'am.
Okay, all right, that's all my questions. Thank you so much.
Any redirect?
Briefly. You mentioned children. Were there children in the vehicle of the defendant?
Yes, sir. There were 3 children, I believe.
Okay. Do you know what their ages were?
Off the top of my head, I do not. I don't want to misspeak. I believe the oldest maybe being,
I'll rephrase.
okay, yes, sir.
Were they car seat age?
Yes, sir.
Okay, that's all I have.
May this witness, oh,
I just have one more clarifying question.
go ahead.
You said that he was allegedly pointing the BB gun at the children?
At children, I don't know specifically his children, children outside of the vehicle. All we had was what the dispatchers received from the caller.
Okay, so it didn't specify if it was the children in the car or elsewhere?
Yes, ma'am.
Okay, thank you.
Anything further?
No, Your Honor.
May this witness be excused?
Yes.
Thank you, sir. You're free to go.
Yes, ma'am. Thank you, Your Honor.
All right, next witness.
The state would call Jason Misley,
Could you spell that last name?
Misleh.
Thank you. Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. Just have a seat right there.
Good morning, sir. How are you? Or afternoon.
Good afternoon, sir.
Can you please state your full name for the record?
Jason Edward Mislow.
And how are you so employed?
I work for Destiny Worship Center Church in Fort Walton Beach as facilities and operations supervisor.
What do your duties entail?
Maintenance of the building, oversight, just make sure the building's up and running and ready for the weekend and throughout the week for the groups that come.
Do you recognize the defendant?
Yes, sir.
How do you recognize him?
From the day of the altercation that we had.
Could you describe what he's wearing today and point towards him?
Orange jumpsuit sitting in between the lady and the gentleman at the right.
Would the record reflect that the witness has identified the defendant?
The record will so reflect.
And is the Destiny Worship Center inside of Okaloosa County?
Yes, sir.
What happened on June 8th?
We were wrapping up for the day. Services had ended. I'm entitled to make sure the building's ready to be cleaned and all the doors are locked. My wife had went around to the back to retrieve our truck to pick me up from the doors. As I was coming, I got a phone call, FaceTime, and she's like, I need you over here now. When my wife says now, I usually know there's something going on. So as I get over there, I already had those doors locked on the children's side. I unlocked it, she come in, I said, what's going on? And then she said, do you remember the gentleman we had a little bit of an issue with at the last service? I said, I recall y'all talking about it a little bit.
Can I stop you there?
Yes, sir.
What do you mean?
I guess when he went to come in to check in his children at the check-in desk, he got frustrated with the people at the counter because they weren't going fast enough. At that time, when they were dropped off into the rooms, they weren't put in the right rooms. So the volunteers noticed that some of the kids needed to be put in different age group rooms. So they did, but after the service, when he came to get his kids, they let him know, hey, look, we had to move one of your children to this room. He got a little bit of attitude with the female safety person, so she backed off and let a gentleman on the safety team. She didn't know if it was due to a woman coming up to him or not, so she didn't want to cause a big scene. At that time, the gentleman was able to, talk to him and everything was resolved. Got his children and had left for the day.
That was the week prior?
That was the same day.
Same day?
Yes, sir.
Okay. Once you locked the doors and your wife was picking you up and you got that call, what happened next?
As she came in the building, I was like, what's going on? She, asked me, did I remember the gentleman from earlier on? I said, I remember y'all talking about it. Well, that's him in the truck. Well, when he pulled in the parking lot, she said, because she was sitting in our truck waiting for me to come out. We have tinted windows so you can't see her. She said he was in the corner in the parking lot taking pictures of the church. He pulled up to our doors, sat there for a minute, and then took a parking spot directly in front of the children's doors. At that time, a gentleman in a gray car, if I can remember correctly, got out, came around, and opened the door. My wife's still in the truck. A note fell out. He picked it up, and at that time, the gun went to fall out. The occupant of the truck grabbed the gun and brought it back inside. That's what my wife saw. So it freaked her out. So she's like, babe, I'm like, you know, it's Florida. I know everybody has guns. I get it. I said, are you sure? She's like, it looks just like your military. I said, okay. Everybody's got guns. We'll just wait and see what goes on. 15, 20, 25 minutes, they sit in the vehicle talking. The passenger exits the vehicle. I'd reached out to one of the officers that volunteer during Sundays. We usually have 2 officers at our church at all times. And I explained to him what was going on. He said, we'll call the non-emergency number. He said, you know, they can come by and just see what's going on, make sure he's okay.
So
said,
at this
"Okay."
point,
I'm
sorry, so
sorry.
at this point, there is no threats that were made?
At that point, no, sir. We were both inside the building. There was no threats.
Okay.
The passenger gets out, gets in his vehicle and pulls off. My wife's standing at the doors, glass doors. And Mr. Castro leans out his window and he says something. So my wife cracks the door and is like, what? He's, are you taking pictures? She's like, yes, I'm taking pictures. You know, we just want you to leave the property. We don't want any problems. Shuts the door. He pulls up and kind of turns to the left where he's kind of sitting horizontal or parallel to our doors. She's like, babe, he's not leaving. So I walk out. I'm like, hey, just leave. We don't want any problems, you know. He's like, well, take a picture, take a picture. I'm like, I don't have my phone. So I figured if I walk back in the doors, he'd just pull off. I come inside and we have a desk where we do check-in for kids. My phone was right there. I grabbed it. She's like, babe, he's still sitting there. So I went out and he's like, again, take a picture. So I just snapped him with my phone and he's calling out his phone number. And about that time, my wife yells gun, and as I look, where the mirror is, the steering wheel, the door, there's the barrel of, to me, being in the service, it looked like an assault rifle, just like I have at my house. Well, next thing I know, the gun is pointed kind of flat across the door. I pulled my weapon. I'm like, man, look, you got kids in the vehicle, stop, please, we don't want any problems. I'm like, just go. At that time, he laid the gun.
Can I pause you?
I'm sorry, sir.
Can I stop you?
Yeah, I'm sorry.
When the gun was pointed at you, did that elicit any feelings?
Fear, of course. It triggered me back to the service. I've been in that situation, so.
Okay.
Yeah, I mean, fear, right off the bat. I knew I was looking at the barrel of a gun, and it was, yeah, so.
Once you had that fear, then what happened?
I pulled my weapon on him, asking him just to drop the weapon, you know, leave. At that time, you know, he takes the gun from laying over the door, pointed at me, and he leans it straight down. And he's like, it's a toy, come closer, come closer. And my experience in the service, I'm not going closer. I think bad things happen. And he's messing with it, and it's, to me, it was like he was having a malfunction. So at that time, I kind of started stepping backwards towards the doors, like, man, just leave, just leave. At that time, one of the other safety personnel was inside the church that was overseeing, we had VBS, Vocational Bible Study, coming up. There's kids and women in there. He came out, I guess he saw what was going on, he pulled. At that time, Mr. Castro picked the gun up, kind of rocked over a little bit, and then kind of threw the gun inside the cab. I was like, just leave. And as I'm walking backwards towards the church, he starts doing a burnout, goes out the exit, almost hits a huge pine tree, overcorrects, power pole, pine tree. He's going right for it. He corrects it and comes to a stop right in the road. And he just sits there. And then he pulls forward a little bit, and by then all the police had shown up on scene.
You said that you actually witnessed the firearm or the gun in the defendant's possession, pointing at you, correct?
100%, yes, sir.
Would you be able to identify that weapon?
Yes, sir.
If you had it today?
Yes, sir.
let the record reflect that there is a person from, I believe, the Fort Walton Beach Police Department with a long box who has just cut open the box with scissors. Okay, and now Mr. Sprouse is holding
Yes, sir, but the front sight was up.
the object.
Like this?
Appears to be a firearm.
Yes, sir.
You see an orange tip on this?
No, sir. I observed it as a suppressor that we use in the military. On the front, that's what ours look like on the front of our weapons. It silenced the rounds.
How long were you in the military?
Almost 6 years, sir.
Okay. And you carried something like this?
Yes, sir.
How would you describe this?
That's a short-barreled rifle, assault rifle we use in the service with a collapsible stock. With the front, it looks like it's suppressed with a forward grip. I was thinking, when I look at it, it's 5.56 or 2.23.
Does this look real to you?
100%.
So did I hear you correct that 2 people from your church, including yourself, actually drew down on Mr. Castro Martinez?
Yes, sir.
Because, at least for you, that you were in fear, that you were in danger?
Yes, sir.
Did you think that you were going to get shot?
I thought there was going to be a shootout for sure. Yes, sir.
But did you know that there were children in the backseat of his vehicle?
To be honest, yes, sir, I did, and that's the only reason I think it ended the way it did.
I have no further questions.
All right, Ms. Farkas?
Good afternoon, sir. How are you?
Good afternoon, ma'am.
Just a couple brief questions. I just wanted to clarify, at first you said that your wife said that my client was someone who'd had an issue the previous week?
No, ma'am.
But then you said it was earlier that day?
It was that day.
Okay.
The only one day.
Okay, I just want to make sure because
Yes, ma'am.
my notes were a little fuzzy. Okay, skipping ahead a little bit, you said that Mr. Castro Martinez was asking you to take his picture.
Correct.
Was he still in the truck at the time?
Yes, ma'am.
Okay. And then he was calling out his phone number.
Correct.
Did he say why?
He wanted me to send it to him or something like that.
Okay, okay. And was there any tint on the windows of his truck?
Back glass, I know for sure, were the back doors, it's a 4-door truck, were totally black.
Okay, so how did you know that there were kids in
I
the
could
back
hear
of
'em.
the? Okay, I'm sorry, what did you?
I could hear 'em.
You could hear them,
Yes,
okay.
ma'am.
So you took his picture, did you send it to him?
No, ma'am.
No, it didn't get to that point?
No, ma'am.
Okay. That is all my questions. Thank you so much.
Anything further?
No, Your Honor.
May this witness be released?
You may.
Thank you, sir. You're
Thank
free
you.
to go.
Thank you.
Mr. Sprouse, may the evidence be taken?
Yes.
in the courtroom? Okay, thank you. I guess I shouldn't say evidence, the item. All right, Mr. Sprouse, anything further?
No, just argument.
Okay. And does the defense wish to call anybody?
No, Your Honor, no witnesses.
Okay. So, Mr. Sprouse, whenever you're ready.
Yes. Your Honor, we are here on Florida Statute 907.041, pretrial detention. The defendant is charged with one of the enumerated crimes under subsection 2A, 5A. That is aggravated assault. In this particular case, it's aggravated assault with a deadly weapon. I do have case law that states whether or not an object is a deadly weapon is up to the jury. If I may provide it with the court, I have provided a copy to defense counsel.
Yes.
I'm in possession.
Thank you. Thank you so much. I have been handed Bryant versus State, 302 Southern 3rd, 995. It's a First District Court of Appeal case from 2020. And it's actually out of Walton County.
Yes. So I will spare the court in doing the court's job and interpreting the case, but I just want it for the record for later. This situation that Mr. Castro Martinez created was extremely dangerous for the community. You heard testimony that the only reason there was not a shootout is because the patrons of the church had wherewithal to understand that there were 3 children in the back of this vehicle. Somebody who is willing to put their own children in such a dangerous position where there's imminent danger of a shootout on church property. There's no other way that we can assure the community is safe when he's willing to put his own 3 children in that danger. So we would ask that you grant the state's motion for pretrial detention based on the facts that the defendant is charged with. He's going to be charged with 3 counts of aggravated assault, 3 counts of child neglect or abuse. I still have to speak with my colleagues on how to move forward with those, CAC type charges. And that there's no other means or way or conditions that are going to ensure that the community is safe other than detaining Mr. Castro Martinez for dependency of this case until trial. Thank you.
Thank you. Ms. Farkas?
Thank you, Your Honor. Just briefly, I would like to draw the court's attention to the first appearance paperwork. Mr. Castro Martinez has no history of failing to appear for court. He has 0 felony convictions. He does have a couple misdemeanor arrests. However, he has always appeared in court. If he were released, he does have an address in Fort Walton Beach where he lives with 2 roommates. There is no indication that he wouldn't be able to return himself to court or abide by any strict pretrial services standard, such as a GPS monitor, weekly or multiple times a week reporting. We also, just as to the facts of the case, we did not hear any testimony from the mysterious man who was speaking with my client before everything transpired, apparently got in his car and drove away. I do believe that this raises some questions about what actually happened on June 8th that turned into this altercation. Of course, we cannot dispute at this point whether or not the BB gun is a deadly weapon is a question for the trier of fact, and so that's not at all in question at this time. But I wanted to raise that we did not hear anything from that particular witness, who I believe is fairly crucial to a determination of whether or not the fear was founded. We did hear, of course, from the other witnesses, but I would like to just reiterate that my client has no history of failing to appear for court. There's no indication in the court record that he wouldn't be able to do so. These are very serious charges, and he knows this, but I would like, as always, to ask the court to consider the least restrictive means and consider setting a cash or professional bond and strict pretrial services rules and a GPS monitor at $1 a day. Thank you.
Thank you. The court finds that the state has met its burden to establish pretrial detention. The court finds that there is a substantial probability based upon the defendant's, statute says, I believe, past and present. The court is primarily considering the facts of this particular incident that gave rise to these charges. That the defendant there's a substantial probability that the defendant committed the crime based on the evidence that I've heard, and that the factual circumstances of the crime do indicate a disregard for the safety of the community. Everyone is very fortunate that there was not a shootout in the court, or in the church parking lot. There were defendant's three children were in the vehicle. I saw the BB gun in question. There is no orange ring at the top to indicate that it's a BB gun. A lot of times airsoft rifles or BB guns have the orange ring at the top. This one didn't. It looked, to the court's untrained, I have no military background, but it certainly looked like a real weapon from where I sat a few feet away from it. I can see how one of the witnesses, who does have a military background, thought it was a real weapon. The court does find that the state has proven the need for pretrial detentions and has met their burden of proof to do so today. The court will order pretrial detention. Are there any other findings that the court needs to make on the record from Mr. Sprouse?
No, Your Honor. That there's no other way to protect the community.
No. Under the facts of this case, the court does not. I'm aware that the pretrial or the first appearance paperwork says no prior failures to appear. I'm aware of that. However, the evidence that was just presented of the facts surrounding these offenses are quite disturbing to the court. And the court does find that there are no conditions of pretrial release or bail that the court believes would reasonably protect the community from the risk of harm from the defendant. So pretrial services is not sufficient, not going to be sufficient in this situation under the facts that I heard. So pretrial detention is ordered. Is So the defendant will be held in jail until further order of the court, and let's find out when our next court date is going to be.
Currently set for felony plea day on July 17th.
Okay, July 17th is arraignment. And is there anything further I need to address?
No, Your Honor, thank you.
Thank you. Anything from the defense?
No, Your Honor.
Okay, thank you. Right here is the... All right, next we will start our 1:30 docket. I'm sorry for everyone who's here for the 1:30 docket. We are running a little bit behind. Thank you for your patience. All right, do I have private counsel present? I see Miss Merrifield, I see Mr. Harper, I'm not sure.
My hearings are a little bit later, so.
Oh, okay, thank you.
Your Honor, as are mine.
Oh, okay, thank
How's
you.
that one, Your Honor?
All right, come on up.
Jim Ballack representing Sean Guevara.
Okay, let me
Case
find.
number 25 CF 847.
Oh, yes, okay, 25 CF 847, Sean Guevara. Is he present?
He's present and approaching.
Thank you.
I filed a notice of appearance and not guilty plea and a waiver of his future appearances, but I guess the clerk's website's down for now. But I figured I'd come in person and make sure we take care of this.
Thank you. Yes, there has been a problem with the e-portal over the last week, I've heard, and it's been pretty widespread. And also, the clerk's office just switched their software. So, there's a little bit of a glitch between my system and the clerk, so.
I saw that the next court date's already set for August 11th.
August 11th at 9 o'clock.
Okay, we'll be there now.
Thank you.
Thank you, Your Honor.
Thank you. And I see that Mr.
Was the information filed on that one?
Oh.
Yes, yes.
Okay, thank you. And I see Mr. Catalinic has a client on the docket, but I don't know if he filed a written plea.
I'm not sure it isn't. Let me see one date.
Okay. Let me see if the state might have received one. To the state on 25 CF 1008, Stephanie Berryhill is the defendant. And I see that Mr. Catalinic is representing the defendant. And you may have gotten e-served with a written plea of not guilty. There's just apparently not one that's posted to the court record yet. Do you know if you've gotten one?
Your Honor, this is going to be Miss Bosso's case.
Oh.
I believe she might be in the jury. Or she's in Judge Stone's court right now, so
Okay.
hopefully we can have an answer when she returns.
Okay. So Mr. Gates and Mr. Medina, do you want me to just start going down the docket?
Your Honor, I do need to talk to inmates. Is there any way I could call an out-of-custody client just to
Of course.
take care of
Go ahead.
Legend Wesley Adams? Mr. Adams has been offered a deferred prosecution agreement resolution. He may or may not wish to take it. If he does wish to take it, he'll probably decline the services of the public defender and save himself $150.
All right, this is case 25, CF 986. Good afternoon, sir. You look very nicely dressed for court today.
Thank you, I appreciate it.
Sure, thank you. Could you tell me your name?
My name is Legend Wesley Adams.
Okay, so, sir, you're charged with 1 count of trespassing at a construction site. Let me just take a look at that.
Jenna, I did file, I'm sure you're looking for the information. I did not see that it's hit yet, but I do have a copy of it here. The defendant does want a copy of this information. It is as charged to the trespass at a construction site.
Okay, and I believe that's a third-degree felony, correct?
Yes, ma'am.
All right, so, sir, well, did the state make an offer to?
Yes, Your Honor, in this type of situation, the state did offer a deferred prosecution agreement with the just basic terms of you'll pay $200 court costs within 90 days, don't get in trouble for 90 days, and don't go back to that property, the Santa Rosa Mall, for 90 days. If all of those things are completed successfully within 90 days, the case outright will be dismissed.
So I don't want you to say anything incriminating. So that's what the state offered you. You are under no obligation to say anything or to do anything right now if you don't want to. I will be happy to confirm the appointment of the public defender's office for you, to provide you with a lawyer. It looks like one was appointed maybe at first appearance. But if not, I'll be happy to appoint one today. How do you wish to proceed? Would you like me to appoint a lawyer for you, or?
Sorry, it's my first time doing this. No, that's fine. I actually realize I'm going to sign this agreement if that's,
Okay.
Okay.
You're going to go ahead and do that?
yes,
All right.
ma'am.
Wonderful.
For your honor.
He did file an application, it was approved, so he has been assessed.
Oh, Mr.
Can
Medina,
he be rescinded, his application, can it be rescinded?
it's already been, the clerk's already processed it. That would have been prior to today.
But the $100, he's very new.
Yeah.
He still wants to do the deferred prosecution agreement. It won't save him the $50 for the application, but it'll at least save him the $100 public defender fees. Good luck.
Okay, so is there anything that the court needs to do, or you just need to?
There's a pen right up there, you can sign it. You can either hand it to a bailiff to give it to the clerk, or I can do that at the end of the court date, but
Your Honor, if I could suggest too, is if he has a smartphone, he can make a
picture.
photocopy of it so that he knows exactly what he has to do. Plus, it sounds like the clerk is saying he owes $50 more beyond that. So I would want to make sure that he understands that it's $250 total, not $200.
Okay. All right. Would you like to take a picture of that with your phone?
Yes, ma'am.
That'd be a smart thing to do. That way you have it.
case number is at the top as well, so you can do that to pay your fees as well.
Oh, how great.
And could the public defender be relieved, Your Honor?
Yes.
Thank you.
No.
That's not mine, sir.
All right, thank you, sir. That's a wonderful opportunity that the state has offered, so as long as you comply with the agreement, then they're not going to pursue the case against you. They're going to
Okay,
drop it.
awesome. I appreciate that.
Yes, so does he need to get that to the clerk, or, okay, maybe hand that to court security behind you and they'll get it up here to the clerk.
Just make sure everything's anything.
Looks good.
Good.
Perfect.
All right,
Thank you.
good luck to you, sir. Thank you. I don't see Ms. Farkas present. Is Dallas Carpenter present, 25 CF 972? Linus Cotto, C-O-T-T-O? Inmate. Actually, I was just trying to find the ones who are not in custody. Is Leroy Figures present? Okay. And Mr. Gates, we can go ahead and line up your client.
Yes, Your Honor, the injured keys is an inmate.
Yes.
Injured keys?
Sorry, Ms. Farkas, I was trying to call the out-of-custody
I apologize.
people.
Yes, Leroy Figures, I spoke with Mr. Gomez, who's the ASA handling Mr. Figures' case. Mr. Figures was here, he was here all afternoon. He has pneumonia, so I requested that he leave for my sake and everybody else's. But speaking with Mr. Gomez, very frustratingly, the state is not ready to resolve Mr. Figures' case at this time. Mr. Gomez is emailing myself and my assistant to schedule a meeting without putting too much on the record. As with the rest of the RICO cases, we are very eager to resolve it, but there is unfortunately nothing I can do at this time.
Okay.
So we need to continue his case. I suppose we could put it all the way to the pretrial date and then move it up if necessary.
Okay.
I think is probably the safest bet, unfortunately.
Has
Okay.
the information been filed?
Yes. I believe
Not
so.
in the current case that we're here on.
25 CF
Oh, sorry.
1011.
I apologize. I was just jumping ahead to the
That
way I
is,
think about a controlling case.
that's currently charged as a felony DWLSR.
Yes. DWLSR.
It's
So, sorry.
We are still reviewing that case. It's more than likely that it's gonna be sent down to county.
Okay.
But we
So
are still reviewing it, so that's why information has not been filed.
I apologize, Your Honor. I've also had a long day.
why don't we put the case on the next arraignment docket,
Yes.
which,
Can,
yeah,
well, I guess if it's going to be moved down to county, then I
Well,
shouldn't
then-
bother entering a plea of not guilty on his behalf.
I would say if you gave us 2 weeks to arraign it, for a placeholder, right?
I'll put it on my arraignment docket, then obviously if it goes to county court,
Yeah.
that date will be canceled and it'll be reset in county court.
So the next date is July 17th.
Okay, it'll be July 17th if his case 25 CF 1011 stays in circuit court. So I'll just put July 17th at 1:30 for arraignment.
Thank you.
Sure, and again, if.
The other
since
one
the
is
state
already
hasn't-
set.
Yeah, they haven't filed charges yet, so if they file misdemeanor charge, then that will be a different court date, and the 17th of July will be canceled in here.
Okay. Thank you, Your Honor. I
Sure.
apologize for my confusion.
No problem. So, what about Dallas Carpenter, 25 CF 972?
I do not have a record to make.
Okay, let me see if.
Oh,
Oh,
I'm sorry. I just opened my file and it looks like a private attorney filed a written plea of not guilty.
okay, let me take a look.
Michael Gilbert?
Oh, okay, that has not made its way to the court file yet.
At least what I have says
Okay.
that it was filed on June 12th, but that might have been something that got lost in the fray.
Do you have anything?
I don't see it yet.
Okay.
Would you like me to?
Oh, yes, I would love to see
Take a
that.
minute.
Yes, come on up, thank you.
Yes. You waived the appearance and.
Yes, I actually, I mean, it's e-filed, and I see it.
Was there an information filed?
Yes, I have a copy of it, if you want one.
Okay, thank you, Ms. Farkas. All right, so Dallas Nicole Carpenter, that's 25 CF 972. Mr. Gilbert previously filed a written plea of not guilty because of the delays with the e-portal and the technology issues. That has not made its way to the court file yet, but I just looked at it, so.
Your Honor, I'm not sure if we filed, and I don't think that we need to file a motion in order to withdraw if the PD's office could be relieved given that someone else's.
The PD's office is relieved in that case,
I
and
need
I'm
this.
recognizing Mr. Gilbert as attorney of record.
Okay.
All right, and then, yeah,
I need to speak with Ms. Basso outside. I think that I have a couple people where, I have a couple incarcerated individuals on for arraignment and then a couple on at 2:30. If I
Okay.
could step out to speak with Ms. Bosworth.
Sure, I'll go ahead and take Mr. Gates's case, and then Mr. Medina, I believe, has one incarcerated as well. So I don't see Mr. Medina in the room, but we will take that case soon too. All right, Mr. Gates, it looks like your client is Andrew Keys, 25 CF 1012. And he will be brought out momentarily.
Does Madam Clerk not need the information for carpenters?
If you announced its file, that's enough.
Okay.
Yeah, thank you.
In Travis case, on behalf of Mr. Keys, we have a plea agreement to be filed.
All right. Yes.
I reviewed the score sheet with Mr. Keys. It will be a downward departure for the free minute.
All right, thank you very much.
State announce the basis.
Yes, Your Honor, this is a downward departure based on a legitimate and uncoerced plea agreement.
All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down. If you'll tell me your name, please.
Andrew Keys.
Thank you, Mr. Keys. In case 25 CF 1012, you are charged with 2 counts of possession of a controlled substance. Each of those is a third-degree felony. Have you had a chance to talk to your lawyer about those charges and any possible defenses?
Yes, Your Honor.
Did you discuss the plea agreement with your lawyer?
Yes, Your Honor.
Did you read and sign the plea agreement?
I did.
All right, and is that your signature on the last page?
Yes, it is.
Do you understand the rights that you give up when you enter a plea?
Yes, Your Honor.
Do you understand you're giving up the right to have a trial?
I do.
Is anyone forcing you or threatening you to make you enter the plea?
No, Your Honor.
Has anyone promised you anything other than what's showing on the agreement?
No.
Are you satisfied with the services of your lawyer?
Yes, Your Honor.
Are you entering the agreement freely and voluntarily?
Yes.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, Your Honor.
I do have a score sheet. It shows 48.4 total sentence points. Any objections?
No, Your Honor.
Is there any exculpatory DNA?
None, Your Honor.
I do find a sufficient factual basis based on my review of the arrest documents. Sir, if you're not a U.S. citizen, do you understand that the plea could subject you to deportation?
Yes. Yes, Your Honor.
All right. How do you plead to counts 1 and 2?
No contest.
I accept your plea. I find it was freely and voluntarily entered. In accordance with your agreement, there will be an adjudication of guilt on both counts. And on each count, you are sentenced to 9 months incarceration in the county jail. Those will be concurrent, and you will get credit for all time served. And is it $615 in court costs, $150 cost of defense fee. That includes the application fee. And you will have 24 months after you get out of jail to pay those outstanding costs and fees before they go to collections. And it states that you are entering the plea without the opportunity to review discovery and the FDLE report. Is that accurate, sir? That you still wish to enter the plea even though you have not reviewed the discovery or the FDLE report?
Yes, Your Honor.
Okay. And you have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you.
Thank you, Your Honor.
Thank you.
And that's all I have before the court today, Your Honor.
Thank you, Mr. Gates.
Thank you, Your Honor.
Morton, if you'll put Shannon on the feed.
I am not sure where Mr. Medina is. Maybe he's talking to somebody? To a client? Ms. Farkas, are you ready for your other cases to be called?
My in-custody lines? Is that?
Yes, or
Yes.
do you have any out of custody?
No, I'm sorry, I have Sheila Connor is set for 2:30, but let's do the
Yes.
rest of arraignments, of course.
Okay.
Yes, I am ready.
All right, so whomever court security wishes to bring out next, I think you have two.
That's fine. I think that we're waiting on the interpreter for Jose Chan, but I do have three or two others who are incarcerated and don't need an interpreter.
I got Shan coming into the feed, give me 1 second.
Well, we've still got,
Randall coming down.
Okay, cool.
we've still got a couple of arraignments.
He's, oh, right. I believe that Ms. Basso, this is her last case.
So I need to go upstairs and harass Judge Stone next.
Okay,
So we
so,
were gonna take his briefly when the interpreter arrives.
oh,
We
okay,
had a change.
okay.
I'll explain it when he gets here.
Okay, so we don't have an interpreter present right now.
She's on her right.
Great. Okay, here comes our interpreter.
Your Honor, if I could briefly let my client know.
Sure.
Jose Chan Velasquez, 24 CF 1477. Thank you for this. Trying to speak with my client. And he is present with the interpreter as well, who I believe is already sworn in.
Yes.
Would you like me to go ahead and proceed? Okay. Judge Clark, ma'am, originally this was special set for today because we thought we might have a plea, but Ms. Farkas was out of town, and then I also needed to speak with my victim to see if they were in agreement. She is here. We actually spoke before today, but we spoke today again. She is vehemently opposed to the agreement, and I cannot in good conscience agree to it over her wishes. She does wish to see the defendant incarcerated or taken to trial after what has happened to her. So we respectfully will ask for a continuance for it to be set for a date certain in the next cycle, because this is a live victim, and I know there's some intricacies in Ms. Farkas being able to get ready using an interpreter, so next week would not be available. But you know, I do apologize to the court, but I cannot in good conscience proceed with this plea.
Understood.
Sir, I think we're asking for the continuance for plea or trial. That would give me time, as Ms. Basso said, to speak with my client and to make sure that if we are moving forward to trial, that we have an interpreter.
And certainly, if we get an answer prior to that, then we would request with the court to move it up if we need to.
Yes. Do the parties anticipate being ready for trial on the next or the upcoming cycle after this one, which would be either the week of August 25th or the week of September 2nd?
Yes, ma'am.
Yes, Your Honor.
Okay. Then, Ms. Basso, do you know offhand if either of those weeks would be bad for your witnesses?
I don't know offhand, but I just actually looked at one of them, and my most important one will be available.
Okay. Let's plan on the first week.
I already have one set that week, but I can make it work. It's just, my other one's just a one-day trial. So if that work, whatever works out with the court's schedule when we get closer, I will make it work with mine.
How many days do we expect to need?
We might need 2, ma'am, just because of the interpreter.
I think that's a safe bet.
Okay.
Because everything will essentially be said twice.
The reason I'm aiming for the first week, and we can readdress this as we get closer, is because the second week is a short week. It's only 4 days.
What I will do, ma'am, is I will reach out affirmatively to all my witnesses and then let Ms. Farkas know, and if there's any issues, we'll advise the court in advance. Thank you for understanding.
Thank you.
So in the meantime, I guess the next pretrial conference date?
Would be August 13th at 9 o'clock. And we will aim for trial during the week of August 25th.
Sounds good.
I'm not going to hold you to that depending on witness availability, but that's the plan.
Thank you.
Sounds good, ma'am.
So
Thank you
we
for
may
hearing
need the
this.
second week. I'll just wait and see as we get closer, but as you're looking ahead, plan on that week.
Thank you, Judge Clark. May I be excused to go to Judge Stone now?
Yes.
So thank you for taking us out of order.
Thank you.
Thank you, ladies.
All right, Ms. Farkas, I think you have a couple of people who are incarcerated on the arraignment docket. So whichever one court security has up and ready to go would be fine. I think there is Mr. DeVore and Ms. Cotto.
Yes.
And Mr. Medina is present, and he has Mr. Brooks.
Yes,
So we
we're
could
ready
call
to
that one
proceed
either.
Whenever, Your Honor.
Okay. So
And
any,
and by the way, Your Honor, we're also ready to proceed on the 2:30 docket with Andrews and back off whenever
Sure.
the court wishes.
sure. Okay.
Judge, I'm also ready on my 2:30 docket as well.
Thank you. So let me finish the 1:30 docket. We have apparently 3 inmates to bring out.
Your Honor,
Mr. Catalinic, I sent him a message. He advised that for Stephanie Berryhill, 25 CF 1008, he filed the plea on 5/21.
Excellent. Thank you.
Was an information filed?
Yes, sir.
That is Ms. Bossow's case. I could check our system to see if it was done.
If you could, please.
Sure.
All right, and Ms. Farkas, is this case 25 CF 1020, Mr. Jason DeVore?
Yes, it is. He
Thank
just informed me he has a brief question.
Go right ahead. All right.
This is Mr. DeVore. He would like to enter a plea of not guilty today. I believe he's already on the August 11th docket.
Yes.
I suppose we can leave it on that docket, and if he is still incarcerated at that time, we'll move it to the 13th.
All right. Thank you, sir.
Was there an information filed?
Information was filed, and I'll inquire, is this going to be handled by the attorney that's handling his other felony case?
So he was just asking, that was what he was just asking me about, actually.
Okay.
He just informed me that he would like me to handle both cases. I didn't know that there was another case. I don't know who's assigned to the other one.
Jason Cobb.
Oh, okay.
And we've done depositions. We had an agreement in principle until Mr. DeVore picked up the newest charges.
The other case is 24 CF 2490, and I'll pull that up really quickly. I believe there was a motion to withdraw filed by the PD's office, which...
Right, because he was already represented. A motion to withdraw in this case?
No, on the
Oh.
the other case. Let me find it. Okay, I'm looking at 24 CF 2490. The Public Defender's Office was initially appointed in that case, and there was a motion to withdraw in November of 2024, and it states that the Public Defender's Office represents someone else, Mr. Hutchinson in 24 CF 1132, and so that was a conflict, so the PD's office withdrew.
Okay.
And
so
then I
I'll need
appointed
to-
regional conflict, and they withdrew, and that's when I had to appoint registry counsel, so Mr. Cobb was the next on the list.
So I will need to look into, make sure there's not, if there is still a conflict, then we would potentially have to withdraw from this case. If not, then if Mr. DeVore wants us to handle the original one, I don't know if we could do that. At this point, I'm only representing him in this one. Yeah.
I don't think it's going to be conflict, because I think it's been more than, well, I don't know, it depends on the judge that says. But on the old one, we definitely could.
Right.
Okay, well,
So we'll handle it for now. He's entering a plea of not guilty.
I think we probably, in light of the fact there are two cases and bond is revoked in the 2024 case, I think we probably ought to go ahead and put the case on August 13th
Thank
for
you.
the next court date. August 13th at 9 o'clock. All right, thank you.
Madam Clerk, there was an information filed in 25 CF 1008. It was filed on June 16th.
Okay, thank you.
You're welcome.
All right, and we have two more on our 130 docket. All right, this is case 25 CF 979, Linus Cotto, and she is present, and Ms. Farkas is present.
Yes, Your Honor. Ms. Cotto will enter a plea of not guilty today. I believe she's on the August 11th docket. If we could put it on the 13th.
Yes, August 13th at 9 o'clock for pretrial conference. Mr. Medina, your case is next for the 1:30 docket. It's the last one.
Thank you, Your Honor.
Thank you. All right, and Mr. Medina, your case is 25 CF 1007, Jackie Brooks.
Yes, Your Honor. Mr. Brooks is approaching. I just received some information from the state. He's been accepted at Project Hope in Crestview, but I need to inform him of something. Brooks, at this time, my understanding is the state's not prepared to enter a deal, at least one that would get him out of jail. And because it's likely that eventually we'll be able to get a Project Hope Crestview deal, which he wants, it's in his best interest to go ahead and enter a not guilty plea today. He certainly doesn't want to agree to a prison sentence, and I don't think the state's prepared to make any other kind of an offer that would get him out of jail today.
There is no offer. I have yet to speak with my victim in this case, so until I do that, there is no offer. Your Honor, I did file an information. I do have a copy of it here. I did file it as it appears on the docket. Battery on a 65 or older, resisting an officer without violence and obstructing justice.
Your Honor, he'll waive formal reading in our not guilty plea. He can remain on the August, I think it's probably going to end up being August 13th, and if we can accelerate it because of a victim input with the state, then I'll certainly try to do so.
Okay, so that would be August 13th at 9 o'clock for pretrial.
Okay.
And yes, if you decide to, if there's a resolution before then, I will find time to bring it in.
Your Honor, could the state advise so that he would understand what the protocol would be for attempts to do Marcy's Law type contact my understanding is the alleged victim may be homeless, and we don't want to be just continuing things, making fruitless efforts to depose somebody and so forth. Does the state have any information about what the protocol would be?
Normally for the state, we'll make several phone call attempts. If you can't do that, I will send out a subpoena to my office to the victim for the victim to appear either at my office or the next court date, whichever is closest. If that goes unserved, a 10-day drop the letter can be sent out. I can have my investigator go out and try to find this victim. But this is just arraignment, so I have not done any of those things yet besides try to make phone calls.
Okay, thank you. I appreciate the information. He understands the process. Thank you.
Thank you. All right, that takes care of the 1:30 docket, I believe. Do you have any others? Okay. All right. We will start on our 2:30 docket, and let me get Zoom going because we had to set one relatively short notice with out-of-town counsel, but I'm not sure if he's there yet. But.
No, what I'm saying is the TV that has the computer on the back of it. So Rachel.
Ms. Merrifield, I'll go ahead and take your case.
Thank you, Your Honor.
Sure. Looks like you have Mr. Alexander Edwards.
I do, Judge. I have Alex Edwards in 24 CF 1388. We also have 23 CF 2081. We had entered a notice for change of plea on 23 CF 2081. That was the intention. However, Mr. Edwards would like to exercise his right to trial, so I'm asking for the next pretrial conference with the understanding that it will be on the trial track for 23 CF 2081.
Okay, so, sorry, I was busy getting the Zoom going.
Yes, ma'am.
23 CF 2081 is not going to be a plea, we need to set trial.
Yes, ma'am.
Okay, what about 24 CF 1388?
So I would like to set 24 CF 1388 because the anticipation was that we had an extremely favorable agreement based on resolving the 23 case. I'd like to go ahead and put that on for the next pretrial as well. However, we're not in a position to try that case. I did discuss that with the state. Based on the 23 case, the older case, the more important case, we focused on that and kind of mitigated down the 24 case. So we may need a little bit more time to get to a resolution on that.
Okay.
But it would be my anticipation that if it did need to be tried, to do it the very next trial cycle after Your Honor's upcoming August cycle.
Okay, and what is the state's position?
The offer is revoked on both cases.
Okay, would you like to put that offer on the record?
I could.
Okay,
It was 4 years DOC, adjudication of guilt. And I don't think there was a mandatory fine. 618 court cost. Well, I think it's actually 515 court cost. Is that correct for leaving the scene of an accident with a
No.
dead body?
I would need to pull up my chart and check it out.
But it would have been.
Regardless, it would be just the standard court cost.
okay. And that offer is revoked? Is that what you said? I'm sorry.
Yes,
just
that offer
confirming.
is revoked. We've been waiting patiently for this date, so we don't want that to happen again.
Okay, when will the state be ready to try 23 CF 2081?
I think the state will be ready in August pending potential deposition of an expert witness. So like the first week of the next cycle. I can't remember the date, but I think it's like August 20th.
August 25th.
And the
Okay.
defense would also be ready. I did discuss that one deposition that we had of the expert witness, and the state and I will, if that needs to be taken, we will work to coordinate that prior to trial so there are no further delays.
Okay. All right, so we will plan on trying case 23 CF 2081 on the next cycle. So this will be the last continuance. By that point, the case will be right at 2 years old, so it definitely does need to get tried then. So no more continuances. We will try it the end of August. We'll plan on trying the case during the week of August 25th. And do we think it will be more than one day?
Probably, actually.
I think the case would probably take 2 days exclusive of jury selection, just based on the nature of the charge. It's not there's not as many witnesses as there typically would be in a case like this, but I would anticipate 2 days for trial and then
Okay.
about a half day for jury selection.
Okay, well, we will hope for the week of August 25th, but trial might actually be the following week, September 2nd. It just depends on how the days work out.
Yes, ma'am.
So be looking at both of those weeks.
And Judge, would that naturally place him on the 8/11 pretrial?
He will be on the
Okay.
August 11th pretrial.
And then in 24 CF 1388, we're also asking for that August 11th pretrial. with the understanding that this would not be a last continuance because Mr. Sprouse and I do need to have a meeting of the minds on that case, but we would anticipate for the following cycle. So the August cycle would be the last. So if we could put that on the 8/11 pretrial as well.
Okay, yes, both will be on the 8/11 pretrial. And for the 2023 case, it'll be the last continuance. We will try it either last week of August or first week of September.
Yes, ma'am.
And then we'll try the 2024 case the next cycle, which
Yes, ma'am.
is end of October or beginning of November. Okay?
Thank you, ma'am. That's all I had on today's
Thank
topic.
you, thank you.
Judge, may I briefly approach?
Yes, yes, of course. All right. And I know Mr. Harper is present, and Mr. Harper, you have a few on the docket. I need to take, I believe Mr. Williams might be on Zoom.
Yes,
And-
Your Honor, he just texted me and said he was in the waiting room.
Okay, thank you. And I have Mr. Nopes as well, so let me go ahead and take Mr. Williams's client. All right, good afternoon. This is Judge Clark, and Mr. Williams, I'm going to take your cases first. I have Ms. Heiler present in the courtroom, and her case numbers are 22 CF 658, 23 CF 1429, 24 CF 2113, 24 CF 2879, and 24 CF 2885. And we, when we were last in court, had planned on taking the 2022 case to trial on next Thursday, June 26th. And then after that hearing, I think Ms. Gaynor may have learned that there's a problem with a witness.
That is
Okay.
correct, Your Honor.
All right. So,
Yes, Your Honor, I got that message from Ms. Gaynor. As I think you may recall, I said last time that I had a trial scheduled the week of the 7th of July over in Fayette County.
yes.
Coincidentally with a different Judge Clark. But we had a hearing on that this morning. The state attorney in the Bay County case. I made him aware of the situation here, and he's amenable to delaying or continuing the Bay County case so that I can do Ms. Hyler's case, that 2022 case, there with you on that week of 7 July.
All right.
So
That's
I
great.
have no objection to Ms. Gaynor's request for continuance until that week. She asked me in her message if I could do the actual trial on the 9th or the 10th. I would prefer the 9th, Your Honor, but I could, if necessary, do it on the 10th.
Well, as of right now, well, first of all, I will set the case on either day. I will be getting some coverage to help me that week because I think I'm going to have more trials than days. On the 10th, I'm going to be in an all-day hearing on a capital case. So I do have to handle that since I'm the assigned judge on that case, and it's a death penalty case. So either the 9th or the 10th, we will have a judge available and be ready to try the case, and we will pick the jury on July 7th. So
That's fine, Your Honor. I prefer the 9th, Ms. Gaynor. How about you?
The 9th will work, Your Honor. I do have one of my officers who's no longer here. He is in Kentucky now. We'll be flying in, but I think we've got plenty of time to arrange that. So the 9th would be fine with the state.
okay. So we will move the trial. We had tentatively set for June 26th because there's a problem with the witness. Ma'am, just so you know, I don't have any trials the next week. It's the 4th of July week, and there aren't any set that week. So the next trial week is the one right after that. It's July the 7th. So we will try your case that week. We'll pick the jury on July the 7th, and then your trial will be on July the 9th. All right, and
And Your Honor, just to clarify, jury selection will begin at 8:30,
8:30.
and then July 9th will begin at 8:30 as well?
Typically, I have the attorneys and the defendant meet at 8:30 so that we can take care of preliminary matters, go over the jury instructions, anything that we can take care of before we start the actual trial with the plan of bringing in the jurors at 9. So,
And then
yes.
any motions and proposed jury instructions, Your Honor, when would you like them to you?
Well, if there are going to be motions that would need to be heard.
Mine would, I will say to Your Honor and to Mr. Williams, it's a basic motion in limine, just follow the rules, follow the law. The only caveat, potential thing that we may argue would be, I would be trying to exclude any comments on body cam or testimony from any other witness regarding any medical diagnosis or things of that nature. But again, that's just,
Okay.
it's a very basic blanket kind of motion in limine.
What would be an agreeable deadline for both sides to file any motions so that the other side has a chance to prepare prior to trial? And if there's time, I'd try to hear it prior to trial. But what would be a reasonable time frame for both sides for a deadline?
Well, I guess that week before is the week of 4th of July, so maybe by the 1st, Ms. Gaynor, does that sound good to you? I don't know, Judge, what you...
I'll be here. I will be here, and I will have time to hear motions that week if I need to.
July 1st is fine, Your Honor.
Okay, so motion deadline for either side would be July 1st, and then as soon as you file it, please send a courtesy copy to my judicial assistant and to me, and then contact my judicial assistant so we can get it scheduled to be heard, hopefully that week, so that we wouldn't delay the jurors or anything if we had to hear it on the day of trial. So I'd like to try to get it done before trial.
Very well, Your Honor.
All right, wonderful. Thank you so much. And Ms. Hyler, I will be seeing you on July the 7th, okay, at 8:30. We'll be picking numerous juries that day. So attorneys need to plan to be with me all day. I don't know in what order we will pick them.
Your Honor, I do want to also put on the record, I think I did this previously, but the offer is revoked at this point.
Okay, so thank you for that, and thank you, Mr. Williams. I'll see you at 8:30 on July the 7th, and we'll pick the jury that day. And like I said, I don't know if I'll be the one trying the case on the 9th or if it'll be a different judge, but there will be one here ready to try the case.
Very well, thank you, Your Honor.
Thank you, Mr. Williams, very much. All right.
Lorena Allen, Dina with Lorena Gail Allen. I'm sorry I didn't get a chance to go around and talk to Miss Allen. I didn't have her file. The reason being, she was in mental health court with probation. Lorena Gail Allen and 23 CF 2478. Apparently, Judge Schlechter did a competency order. She was determined incompetent. Is this matter up before the court? I didn't want to cut Mr. Nopes off, Your Honor.
Yes, we'll go ahead, and Mr. Nopes' case will be next.
Okay.
So, all right, Ms. Allen is present, 23 CF 2478 and 23 CF 2010. And if you'll just let me get my paperwork. I do have paperwork on Ms. Allen.
Yes, Judge.
Okay. And, yes, Ms. Allen was at the state hospital and has returned to us. It's nice to
Yes,
see you,
Your Honor.
ma'am.
I don't have any basis for saying that she's incompetent at this time. She seems to be restored. And unless there's any objection, I think the court could, we could agree that the court could consider her report and determine that she is restored to competency and put her on the mental health court docket where she was when Judge Schlechter ordered the comp eval.
All right, to the state, is there any objection to the court relying on the report from, it looks like Dr. Neville and Carson Zink, who is a master's level psychology intern, that was, let's see, the date of the report is May 27th, 2025.
I have no objection, Your Honor.
Okay. I reviewed the report, and the Florida State Hospital, those professionals that I just mentioned are of the opinion that Ms. Allen has been restored to competency and that she is competent to proceed. It's nice to see you, ma'am. Thank you. So the court will make a finding that Ms. Allen is competent to proceed and that she no longer meets the criteria for involuntary hospitalization. And I have prepared an order, and I have just signed it. And I will hand it to you. So does Ms. Allen now go back to mental health court?
I think that would be appropriate. I don't think there's a need for a non-mental health court control date because I think she should be put on the next available mental health court docket so that Judge Grinstead, visiting, retired judge or whoever's covering that can decide in consultation with staffing and public defender and prosecutor for mental health court, what's the next step?
Let me see when that date is.
Thank you, Judge.
Because I'm not aware.
Well, typically, we're instructed by the mental health coordinator of when to set them in these diversion programs.
Well, in that case, we might need to set the next pretrial here, and then mental health court can intervene.
It's kind of unusual that she's in mental health court and then was found incompetent while in mental health court. Do you want to put her on, because this is I think it was basically a VOP type scenario, because she had already pled out to mental health court, which did a mental health court plea agreement for, I think, 2 years probation with mental health court as a special condition. So there's two alternatives. One is that I, and certainly the state can be copied, will reach out to Susan Thornton with Mental Health Court and ask if they want to put her on the docket. But if the court and/or wishes to put her on probably a miscellaneous docket rather than August 11 or 13.
Okay, what I will do is go ahead and schedule both of Miss Allen's cases for, I believe it's July 22nd is our next miscellaneous day. But that's with the hope that Mental Health Court will put her on their docket, and then our July 22nd date would be canceled. But for now, until that happens, let's put Miss Allen's cases, both of them, on July 22nd at 9 o'clock.
July 22, Your Honor?
Yes, July 22nd.
I'm going to write that down for her, Your Honor.
Yes, July 22nd at 9. But if you hear from Mental Health Court that you're going to be put back on their schedule, that would be the court date that you would need to, that would
Yes,
take
Judge.
the place of this one.
And I'll reach out to Susan Thornton, the Mental Health Court Staff Director, to see if they can put her on a docket for them.
Okay, that sounds great.
And again, the officers of the court and Mental Health Court were much more familiar with what's going on there on the substance of whatever the alleged violation or whatever. So that's the way to proceed. Thank you.
Okay, thank you, ma'am. All right, Mr. Nopes.
Good afternoon, Your Honor.
Good afternoon. I believe that you're here on Mr. Ballou?
Christopher James Ballou. I received this court's order stating a status here for today at this time.
Yes, I was just trying to figure out what is going on as far as his admission to Phoenix House. These are case numbers 23 CF 2001, 23 CF 2029, and 24 CF 2666. I entered an order on June 6th, but during all the technology challenges in the last week with the e-portal and the switch of the system, I have no idea where that order is. I have a copy of the one I signed, but it's in cyberspace somewhere. So let me see. Do you know whether he's still in jail?
I just looked up on the jail website, and it appears that he still is in the Okaloosa County Jail.
Okay. And today was just a status to see what's happening with his being picked up and taken to Phoenix House. So does probation know? Sorry to spring this on you suddenly.
I'm looking.
Okay.
On the 10th, Officer Doobie sent the paperwork to Phoenix House to get him picked up, so we don't know what the delay is as of this moment, but we did send the proper paperwork on the 10th.
Oh, great. And is that on June 10th or?
Oh, yes, ma'am, June 10th.
Okay. So, Mr. Nopes, when would you like to set another status? What I'm trying to avoid, it's happened a couple times, is there's a long delay sometimes in somebody getting picked up for Phoenix House, and it creates a lot of issues. So I'm trying to monitor the situation and make sure he doesn't fall through the cracks and that he actually does get picked up. So how far out do you think we ought to set another status, just to see if he's transported?
Judge, I'm willing to do, I mean, I don't have something else scheduled, but it's best to look at the court. You just tell me when you want, I got the calendar right here, I'll let you look at it.
I mean, I could put it on August 13th, which is the next pretrial, and you would be there that day anyway. That's just, a couple months from now.
Yeah,
Or I
that's
could put him
perfect.
on July 22nd, either one. I don't know if you have court with me that day or not.
July 22nd. I have nothing scheduled at this point. Judge, and I don't know how to actually get an answer to the question of when they are going to become transported.
Yeah, I don't know the answer to that. What I'm trying to do is just make sure that he doesn't linger in the jail. You know, there've been a couple of people that there's been a problem for whatever reason, and they've lingered for months in the jail, just in limbo. So I don't want that to happen to him or to anyone else. So that's why I'm monitoring it. Why don't I set the next status for July? Mr. Dopes, you could either have the afternoon of the 17th of July or the afternoon of the 24th of July, or you could have July 22nd, any of those. I'm just wanting to set a status is all.
Judge, I do know that I've got to be with you on July 17th at 11 a.m. for sentencing on William Thornton.
Well, why don't we just set it then?
Wonderful.
Yes. So July 17th at 10 o'clock. Just a status for Mr. Ballou on all three of his cases. If he has already been transported to Phoenix House, then that hearing is automatically canceled and we do not need to have it. I just want to have the hearing if he's still in jail, to see why he's still in jail and why he hasn't been picked up.
I understand. I'll see if I can speak to somebody out there that might know how to get that answer.
Wonderful. Thank you very much. I appreciate it.
Yes, ma'am. Y'all have a great day.
You too. Thank you.
Thank you. Bye.
Bye. All right, Mr. Harper.
Yes, Judge. I have a couple on this afternoon's docket. If I can start with my out of custody, Charles Crane.
Yes.
Number 4 on the docket before the court on 23 CF.
Yes, thank you. And I
2695.
think Mr. Crane is approaching.
He is present and approaching, Judge. I think the court probably wanted some
Yes.
additional information as to status.
Yes, I appointed an expert 2 months ago, and I'm wondering what's going on with the evaluation.
Yes, Judge. So Dr. Salinas, and this applies to both of Dr. Salinas' cases, was appointed in late to mid-April. When I contacted him for status, because we had court on Mr. Crane's cases in May, he indicated that he didn't have an order on one of them, and he did have the order, but he hadn't done anything as of that moment when I contacted him last. So functionally, he's about a month delayed. When I did speak to him about an update as to what would be the disposition of Mr. Crane's case, I spoke to his office manager actually this morning again. I spoke to her earlier in the week, but I wanted more information this morning. She said that she can have the evaluation, or Dr. Salinas can have the evaluation done the week of July the 14th to the 20th. So that's an estimated time frame for completion as to Mr. Crane's evaluation. And just full disclosure, Mr. Crane has actually not seen Dr. Salinas as of this moment, but I'm going to help facilitate that on Monday, just to keep this moving.
Thank you. Okay, so Mr. Crane,
Yes, ma'am.
I'm ordering you to go to the appointment to see Dr. Salinas whenever that gets scheduled, okay? You
Okay.
have to go, all
Okay.
right? Thank you.
Okay.
And cooperate with Mr. Harper and Dr. Salinas' office to get it scheduled, all right?
Okay,
All right,
okay. Okay, so we're not next.
there will be,
Actually, yeah, she'll tell us. Just-
yes. So our next court date would be, I mean, I could put it on, Well, if he sees Dr. Salinas the week of July 14th, we probably won't have a report by July 22nd.
The estimate that they gave me, I asked her specifically about that, and she said that she could have the report done in that time frame. She specified.
Oh.
I don't know if she's being overly optimistic, but,
Okay, well, I have a couple of options. We could do July 22nd for the next court date,
that's fine with me, Judge.
or the 24th, the afternoon of July 24th. We could do that. That would give Dr. Salinas 2 extra days. Whichever one is more likely that we will have the actual report.
24th is fine, Judge.
Okay, let me take a look and make sure that that is not completely full. I think I have a sentencing hearing that afternoon, and let me see what else. But this hearing wouldn't take that long. Okay, let's go ahead and schedule the afternoon of July 24th at 2:30. And that'll be a competency hearing. Thank you.
Thank you, Judge. The next one I have is number 5 on the docket, Pamela Henson, 23 CF 818. She is present and approaching. I think we have 2 matters for the court.
Yes.
If I can address the competency matter first.
Yes, and I see Ms. Henson is present.
Ms. Henson is present. This is with Dr. McDonald.
Yes.
Dr. McDonald, there was an initial scheduling issue, but they have since resolved the scheduling issue. She has been seen by Dr. McDonald.
Great.
I think that was earlier this month. Dr. McDonald advised me that she's got some additional information she's trying to obtain. It's her belief that she has seen Ms. Henson in the past. That may or may not be true, but she believes it, so she's going to have to pull up a prior report if that in fact is the case, as well as some additional information she's asking. So she's not ready, but she has seen Ms. Henson. So that's with respect to status. I think that if we could set this for August the 11th, I think we should have, it should be, we'll have disposition one way or the other.
Okay.
And that kind of leads me to my second issue. I filed a motion to withdraw. I had certified that a conflict does exist. I have some ethical concerns about bringing that out in a public setting. I don't know if you want me to approach, but at this point, I know that Ms. Henson has long requested that I withdraw or get off of her case, and I have not done so until there was a sequence of events that's until there was a sequence of events that sort of precipitated my filing this motion.
Okay, if you tell me that you have a conflict and need to withdraw, I accept that.
I don't do that. There are a lot of times where clients kind of want you to withdraw of a case, and I don't do that merely at their solicitation. In the sense, I could probably say that she's asked me to withdraw, and I have not for an extended period of time. But there was something that occurred that caused an issue, so we need to withdraw.
Okay. Ma'am, do you object to Mr. Harper withdrawing off your case?
No, ma'am.
Okay. So what I'm going to do is appoint another lawyer for you. And what you'll need to do is, first of all, I want to make sure that your contact information with the clerk of court is accurate, because that lawyer will need to know how to get a hold of you. And then if you'll just bear with me, I'll let you know who that lawyer is. Okay, thank you. So, Ms. Henson, I am ordering you to cooperate with Dr. McDonald if she needs more information from you.
Absolutely, yes, ma'am.
Thank you. And I'm appointing an attorney named Marty Nopes. He was actually just on Zoom.
I seen him.
Okay.
Yes, ma'am, I'm
I'm
writing it
going
down.
to put it down here.
Okay.
So that's from the attorney.
So, and your next court date is going to be, well, I'm tempted to put it on July.
If we can set it on the same court date that Mr. Nopes had in the afternoon,
Yes.
that might be efficient.
That would be, I believe it was the 17th, and I think Mr. Nopes is at 10 o'clock that day. Yes, so actually, July 17th at 10 o'clock is going to be your next court date, because Mr. Nopes, I know for a fact, is going to be here that day, and that way we don't have to wait 2 whole months.
Okay.
So July 17th at 10 o'clock. And that'll be a competency hearing. So did you write that down? Or
I did.
Okay, did you put Mr. Nopes' name down?
Yes, ma'am.
Thank you. Thank you.
Yes, I got all the information.
Wonderful, okay. Thank you, yes. July 17th, 10 o'clock, and Mr. Nopes will be your attorney. And Mr. Harper, if you will send me an order granting your motion to withdraw and put in there that I'm appointing Mr. Nopes to represent Ms. Henson, and that way it'll be in the court record and a copy will be sent to Mr. Nopes. He'll be notified. And ma'am, I don't have Mr. Nopes' phone number handy, but you can look it up, I think.
I will be able to get it. I will reach out to him immediately.
Wonderful. He won't know right in this minute that he's appointed, but you
Yeah,
can
I'll
tell
give
him that,
a day. I'll wait till in the morning, but I'm definitely.
okay. Let him know that I appointed him in court and he'll be notified soon.
Thank
Okay.
you so much.
Oh, sure, and let's make sure that, did you give her updated address? Okay, thank you for providing your updated address, because Mr. Nopes will probably use that to reach out to you. Okay, so July 17th at 10. Thank you, Mr. Harper.
Clint Jones, if that's okay.
All right, Mr. Harper, is your next case that you want to call, is it Clint Jones?
Yes, Judge, he's before the court on 24 CF 972 and 24 CF 973. This is a case with Dr. Salinas. I did provide some additional information earlier about Dr. Salinas and how he's kind of, when I contacted them earlier and indicated that he had not had the opportunity to meet with Mr. Jones yet, I
declare competency. There's no mental health evaluation required. I move the court to dismiss 2 counts of armed burglary, the possession of deadly weapons,
Thank you.
and
Hold on.
resisting arrest without violence upon grounds of lack of evidence.
Thank you, sir. So, Mr. Harper, what were you saying?
So I reached out to him this morning, and he indicated, and I don't know how accurate this is, but he indicated that his office has since moved to Escambia. He's no longer in Santa Rosa County. He's in Escambia. He indicated that he has issues with Okaloosa County not permitting him to conduct evaluations by Zoom, which is kind of the reason why I think we picked Dr. Salinas.
I dismiss my legal counsel. I'll represent myself.
Sir, just a second. So, do I need to appoint a different doctor?
So what I would ask, Judge, in that Dr. McDonald is local, we were trying not to overburden her, but I think I'm going to, hopefully tomorrow, submit an amended order appointing Dr. McDonald to this case, and that way she can see him in person.
Okay, that sounds good. Let's get that done. So, sir, I'm appointing a different doctor to come and see you because the one I appointed before hasn't been there yet.
The court has failed to arrange a mental health evaluation. I declare competency before the court. Is there any objections to me declaring competency? Competency is hereby
thank you, sir.
declared, and there's no objections. But
Thank
I
you.
still, okay, so what? I have a question.
Okay.
Wait, but that takes my legal. That's unjust. I didn't get no paperwork. I didn't get no paperwork.
Please send me that order as soon as you can, Mr. Harper, and I will sign it immediately.
I'll do that tomorrow.
Okay.
Judge, the last one I have is Rayshon Schaffner.
Oh, wait just a second, I'm sorry. We need to put a control date on Mr. Jones, who
Could we
became disruptive and
do the same dates as Mr. Crane's 721? I think that's
it's
an afternoon.
7:24, July 24th at 2:30. How about that?
Yes, ma'am, that's fine.
At 2:30 on both of his cases, which are 24 CF 972, 24 CF 973. His next court date is competency status on July 24th at 2:30, and I will be happy to sign the order switching the doctor as soon as possible.
I will attempt to get that filed tomorrow. Judge, the next one is Mr. Schaffner. He's actually got a litany of cases.
Yes.
21 CF 2362, 21 CF 2364, 21 CF 2399, 21 CF 3297, 21 CF 3299, 22 CF 340, 23 CF 1155, 23 CF 1156, 23 CF 1205, 24 CF 2048, and 24 CF 2049. Judge, Dr. McDonald is doing these evaluations. He refused transport.
Oh,
so
okay,
he's
let me
not
get that on
present.
the record. Mr. Schaffner, is he present? Did he? He refused to get on the bus to come? Okay, I need to make sure that that's documented because I know that he's brought up court date issues before, and so let the record reflect that court security is telling me that Mr. Schaffner refused to get on the transport bus this morning. Okay?
Judge, I have been in contact with Dr. McDonald. She attempted to do an evaluation earlier this month. This is the earliest she could get that from the signing of the order appointing her in April. She indicated that he refused to meet with her. I've spoken to her and she's going to attempt another visit. We are also trying to get some collateral material to see if Dr. McDonald can make a determination based on if there's enough substance and some other issues, because his mother is a fairly good historian of his mental health issues, and she does have some medical records from when he was a child. And if Dr. McDonald feels that's of sufficient quality that she can make a determination based on what she knows and my interactions with Mr. Schaffner, she will, but she might not. She wanted to make that clear if there's not enough. But that's where we're at currently, Judge. She did make an effort to see him this month, and he refused.
Okay, so let me reset this case. I'm a little concerned about loading another one onto the afternoon of the 24th of July because I have a sentencing that afternoon. And sometimes, sometimes these cases or these types of hearings take a little longer than others. So perhaps July 22nd?
That's fine, Judge.
Okay.
Is that at 9 or at?
At 9.
Okay.
July 22nd at 9 o'clock will be competency status or competency hearing, assuming we get the report back, on Mr. Schaffner's cases.
And I think Dr. McDonald did email the state at the same time. She emailed me.
She
about
did,
that.
she notified the state as well, Your Honor.
Thank you.
Thank you, Judge. That's all I have this afternoon.
I appreciate it very much, Mr. Harper. Thank you for giving me all those updates.
Thank you.
Your Honor, I have nothing further today. May we be excused?
Yes.
Thank you.
Have a good rest of your
You too.
day. Okay, and who do we have up next?
This is Harry L. Andrews, 23 CF 1922. Your Honor, the court entered an order that directed a second competency evaluation to be prepared by Dr. Randy McDonald. He advises, and I can't find anything contrary that, the report hasn't been done yet. I can tell that by the benchmark, but he says she hasn't been to see him yet. We're checking to see the status, but I'm asking for a brief continuance so we can get Dr. McDonald's report. I'm sorry, I don't have any status at the moment other than we don't have the report that's needed to take the next step.
Okay, so I know that she's backed up because I just had some hearings on someone else's cases and she was appointed in some of those cases.
Oh, I know that.
Yeah, prior to the order I entered in this case. of
Right.
So there, she is back
And we
up.
had Dr. Zeman see him before, so the second competency, we were using a different expert, so it's just probably unavoidable. At this stage, we'll have to do a continuance for a short period of time.
How about July 22nd at 9?
Yes, Your Honor.
All right, July 22nd for competency.
Thank you.
Sure.
And we are, like I said, hopefully we'll get some information and can share that with the state if we get something back quicker.
Okay, thank you.
Next will be Stanley Backoff.
Okay.
Thank you. Your Honor, Stanley John Backoff Jr. is approaching in 24 CF 941. I have met Mr. Backoff. He is back from Florida State Hospital, and I do not have any reason to disagree with the DCF recommendation that he's restored to competency, and would ask that the court accept the report of DCF and determine that he is competent if the court agrees.
All right, and good afternoon, sir. I'm Judge Clark. It's nice to see you.
Nice to meet you.
Thank you. Thank you. So, does the state have any objection to the court considering the report from its Dr., well, looks like Jennifer Edwards, who is a master's level clinician, and she's supervised by Jennifer Slusars, who is a doctor of psychology at the Florida State Hospital. That report is dated June 2nd, 2025.
State has no objection, Your Honor.
All right. The court accepts the report, and I have reviewed it, and those mental health professionals are of the opinion that Mr. Backoff is restored to competency and no longer meets the criteria for involuntary hospitalization. And the court will make such a finding that Mr. Backoff is competent to proceed. And I prepared an order. I just signed it. I will hand it to the clerk. And we need to set Mr. Backoff on the next court date, which would that be August 13th?
Yes, Your Honor.
August 13th at 9 o'clock.
I do wish to may I make the court aware of something else that
Yes.
I've discussed with him and with Assistant State Attorney Gaynor. I'm going to reach out to the 90-day program and also to mental health court, because it's possible that something like that will be available. He represents that he's done the 90-day program before, so I will pursue that as soon as possible.
Okay. And if you need to bring the case in sooner for any reason, just contact my office and we'll see what we can do about that. So
Yes, Your Honor. Thank
right
you.
now, we've got August 13th at 9 o'clock for pretrial conference. Thank you, sir.
Thank you, Your Honor.
Thank you.
Your Honor, I believe that concludes everything for me. May I be excused?
Yes, have a wonderful afternoon.
And myself as well, Your Honor. Thank you.
Have a wonderful afternoon. Thank you. I'm looking to see who we still have on the docket. I think only a couple.
Yes, I have one out of custody, Sheila Connor.
Yes, okay.
She is present, and we can handle that one now. And then I think I just have one more in custody after that.
Yes.
Yep.
All right, and Ms. Connor is approaching. This is case 2020 CF 56. And we were just in court a couple days ago, I believe, and Mr. Sprouse, the state was going to reach out and speak with the victim.
I did reach out, speak with the victim, and we're not going to be able to offer the same deal that we were in the process of working through. They want their money back, and they're upset about the situation. The outstanding amount is still a very large amount. It's like $30,000, if I'm not mistaken. So the only thing that we can do, to my knowledge, is go forward with a VOP hearing because there's no more jurisdiction left on the count for probation. So like, there's one more month left on the 5-year probation sentence. So I don't think that we can extend her probation any longer. So we would just see if the violation is willful at a hearing.
Your Honor, if I may.
Yes.
I don't wish to waste the court's time. I don't know if there's a way that we can do this without a full hearing. I have the case law that if someone is making every effort to make restitution payments and is determined to not be able to pay, then they cannot willfully violate. That is very well established. We no longer have debtors' prisons in the United States for a reason.
Right.
Probation has opined Ms. Connor's inability to pay, and despite that, the fact that she's been paying every month, sometimes more than she was ordered to. Like I said, we can schedule an evidentiary hearing. There's not going to be anything else to put. I think the irony also being that if the remaining restitution is sent to a civil lien, the complainant will actually be able to enforce the lien against Ms. Connor and potentially garnish future tax returns, those sorts of things that he can't get at this point. So a civil lien might actually allow him to get more back in restitution than he would otherwise. But the fact is that next month the probation expires, the term expires, and she cannot pay, and it's well established. And of course, I'd be happy to have you swear her in and ask questions about her ability to pay.
And the state does not dispute that is what the law is, that we would have to find this, Your Honor, would have to find a willful violation. That's what the law is.
Yeah.
And I don't dispute it.
I've read the violation report, and I think I said something about it a couple days ago that very rarely do I read them and they're positive. This one was. I mean, this really was a positive violation report about, ma'am, how you have complied with probation. You have made the payments like you're ordered to do. Sometimes you made more than what you were ordered to pay. I remember when you were in front of me, gosh, might have been a month or so ago, and I made notes on some of the things you said about how you were trying to pay and make it right. I mean, I remember that.
I will continue that, Your Honor.
Yeah.
I've tried to make it right from the very beginning. I made a stupid, horrible mistake, and I just, if I had the money, I would. If I could get it, I would, and I will continue paying on the civil lien. I will.
Yeah. It says, I mean, I'm still reading from the violation report. It says, the offender has no other violations and has complied with probation to the best of her abilities. I mean, I know we're not at a hearing, an evidentiary hearing, but I suspect that the probation officer is going to get on the stand and say that. And I suspect that would be my finding as well, because I've had other similar cases where someone hasn't been paying their restitution, and it's been night and day compared to your situation. So let me ask this of the state. So you're saying that we've got one more month of probation. An option that is not available to the court is to extend probation. Is that right?
That's my understanding of how it's charged. We can't put her on any more probation. That's
Okay.
my understanding of the law right now.
So if we had a hearing and I found that there was no willful violation and that Ms. Connor was doing her very best to comply and was just not able to,
Yep.
then I would just terminate, her probation would be terminated, period.
And then the restitution would go to civil lien. We end up in the same spot. However, when I spoke with the victim, he said to do whatever the state can and to try to get his money back.
Your Honor,
So my options would be, I would have to find that that Ms. Connor has willfully failed to pay when she had the ability to do so. And then the only option wouldn't, if I couldn't put her on more probation, even if I were to make that finding, I would have to send her to prison or
Correct.
jail
correct.
if there was a willful violation. I
Correct.
don't know, I mean, based on this report from the probation officer, I don't see.
And that's why the state was cutting the deal. But
Yeah.
Your Honor, I would like to
Go ahead.
add that my understanding is that either the state could in theory move forward with the agreement over the objections of the complainant. They've informed him of what the offer was, and I don't believe that Marcy's Law requires him to be 100% in agreement. That aside, I believe that Your Honor, she could essentially plead to the bench, and Your Honor could make the finding that it was not a willful violation. The outstanding issue is that I don't want her to admit to the violation and become adjudicated guilty. This is her only criminal case that she's ever had, and she was given a withhold of adjudication. And so I don't want to get her in a situation where she's admitting to a VOP and is then adjudicated guilty. That would be the only reason I would schedule it for a hearing as opposed to just having her plead it to the bench. But I believe that she could plead to the bench and Your Honor could still maintain the withhold. So I don't know if we can do that right now.
And I don't think I would have a legal objection to that. I don't think I can object to somebody pleading straight up to the bench.
Okay.
I know I can.
So what is the state, I mean, I'm not trying to put any pressure on Ms. Connor. I don't want her to, she can consult with Ms. Farkas about her options. What does the state wish to do? And that's a sincere question in light of the fact that my options are to, what is the state planning? How does the state wish to proceed?
I represented to the victim that the state would do what they could to, frankly, force the hand of the defendant to come up with the money that the victim is owed. The victim is owed $30,000 more dollars.
Actually, $32,206.50 as of April 25th, 2025, and it's probably less than that now because Ms. Connor's probably made a payment since then.
And
But
of course, the problem with the civil lien is that's not guaranteed. There are exceptions to garnishment in Florida. So if she doesn't have the ability to pay on probation, the concern is that the victim's not going to be able to garnish her wages because she's going to be exempt for whatever reason. That's the concern.
If I may, Your Honor, she certainly won't be able to work and
pay while in prison?
rest. Yes, correct. So I'm not trying to be cheeky, but
No,
you know,
I mean,
there's-
that's,
a civil lien definitely won't do anything if she's incarcerated, so.
So how does the state wish to proceed? Do you wish to, do you wish to set a hearing? Do you wish to, I'm not going to.
The state would
figure out how you want to do it.
The state would do a hearing. We would be prepared to move forward on a VOP hearing.
Okay, well, however we want to do that, that's fine.
Yeah.
So the state's offer is, you're not making your offer anymore, we're going to set a hearing. Is that
Correct.
right?
Yes, Your Honor.
Your Honor, if you would hear Ms. Connor in a plea to the bench right now, then I think we can probably resolve it. If Your Honor would feel more comfortable setting a hearing so that we can hear from the probation officer, then we can do that. I would just ask for a very, very short date.
I think we'll need to set a hearing.
Okay.
So, because I'm just relying on a piece of paper, which I don't know if I'm actually, legally permitted to just rely on a piece of paper with no actual testimony or.
Yes, Your Honor.
So, well, I've got time next week.
I have not spoken with the probation officer. In this scenario, I'm not actually sure if the probation officer is the defense witness or the state witness. I would assume it's a state witness.
So we could set the case for next week?
That's fine with me.
Is that, I mean, how are you looking, Mr. Sprouse, next week?
I will check.
I have a hearing on Friday.
If, I apologize, probation has just let me know that her probation officer is in Defuniak. If we could allow him to appear via Zoom, just in case, if he's not able to get here in person or something like that.
I would not have an objection to that.
That's fine with me. So I know I will have to, I mean, Thursday, some of you might be, one or both of you might be here for pretrial detentions anyway, so, okay, well then in that case, let's try to set it on Thursday so you don't have to come to the courthouse 2 days.
Perfect.
Okay.
What?
And then, Mr. Sprouse, if you, I mean, you could reach out to the.
Next week's trial week, right?
What is that?
Next week is.
Yes, it's,
correct?
but we don't have any, I don't think.
Right, so I don't have anything that week.
I think there's just arraignments and miscellaneous in the afternoon after pretrial detention.
I don't even think
Oh,
we have
I'm sorry, I was
arraignments
looking at
next-
July. I've lost it.
So-
Okay,
I
I
might
also.
have a pretrial detention hearing on Thursday.
So let's set it on Thursday because Ms. Farkas is going to be here
Yes.
potentially for that, and you will be here potentially for that, so that way you don't have to come to court on 2 different days.
Is it the 27th?
26th, I believe.
And at what time would you like the probation officer to be ready?
Well, I'll defer to the attorneys. I'm at your disposal.
Maybe we could say 12:30, just in case the pretrial detention hearings go quickly.
Yes, and I'm trying to think if I think I said a couple of other things at 12:30 on. I did set a couple of other things, so maybe we'll say they were pleas, but,
Well, I only showed one.
oh, one. Okay. Yes, we can say 12:30, but it might be, you know, if I have pretrial detention hearings, it might be later than that.
Thank you.
Sure. So 12:30 on June 26th. Probation officer can appear by Zoom if necessary, but the probation officer needs to know that we could be delayed starting. If I have pretrial detention hearings, you know, there could be a delay. And I know I set something else that same day, immediately following the pretrial detention hearings, if any. Oh, I set Mr., yes. So I do have a plea coming in at that time. So we might want to set it for 1, just 1 o'clock.
That's
And
fine.
that way there's not people waiting around for 30 minutes needlessly. So 1 o'clock on June 26th.
Your Honor, I did bring the case law about the inability to pay. Would you like me to give that to you now or wait until the hearing next week?
Next week is fine.
Okay.
I have so many papers on my desk.
Yes,
that-
I understand.
Yeah. So, yes, June 26th at 1 o'clock, and you would notify the victim, and the victim, of course, could come and be present and be heard.
That's correct.
Okay. And then we'll see where we go from there.
Thank you, Your Honor.
Thank you. All right, June 26th, 1 o'clock. Thank you.
Thank you, Judge.
Thank you. And I think we just have one more case.
I believe so.
Okay, I'm so sorry, I just saw Ms. Foley, the staff attorney, sitting there, who's probably been sitting there for quite some time.
I just got here, it's okay.
Oh, good.
Go.
Mr. Delgado's here, he wasn't on the docket. David Delgado.
Is that paperwork for it?
Yes, sir.
What was the first name?
David?
David Delgado?
Yes, sir, it's an early termination of probation, correct? Thank you. Let me find your case, okay? I apologize for your wait. There has been some technological challenges in the last week that a lot of orders and things that have been signed or things attorneys have filed have been delayed in getting processed or getting lost in cyberspace. I think that I remember setting your hearing. so let me just find it, okay?
For the record, the state wasn't in receipt of the order.
Okay, so sorry.
But I think I can get ready for the hearing.
Okay.
I think I may have it.
Okay.
22 CF 1653.
Let me take a look.
That's on his paperwork. Yep.
Yes, I entered an order on June 6th, setting the hearing. And it's one of those, there were several orders I entered that day that are just gone. I can see where it was e-filed. I even have a confirmation number. And Mr. Sprouse, you were supposed to have been e-served, so was the probation officer, Mr. Profit.
Actually, it's Fowler now.
Oh, well, Mr. Profit got served, but, well, was supposed to have been served. I can see where it went through. It says filing succeeded. I can see who was supposed to have been e-served, but with the problems with the portal, who knows what has happened to that. So, yes, sir, I'm Judge Clark. Can
Yes,
you
ma'am.
just tell me your name?
David Delgado.
All right, is that David Delgado Jr.?
Junior, yes, ma'am.
Yes, sir. Okay, you are here on case 22, CF 1653, and you had written a letter requesting early termination of your probation. It was a letter, but I'm treating it as a motion to terminate your probation early. And I'll give Mr. Sprouse a moment to read that and take a look at it. And I am so sorry. Ma'am, can you tell me your name, probation officer?
Samantha Howell.
Miss Officer Howell, thank you.
The state has no basis for objection other than I haven't been able to speak with the victims in the case, of the underlying case. That's the only issue that I have right now as far as at least stipulating to the early termination. So I'd have to object to early term based off my
How about, why don't we do this? Why don't we continue the hearing and give you that opportunity to reach out, and we'll reset the hearing. Let me just take a look.
I'm free next week.
Sir, how are you looking for next Thursday?
I'm open.
Okay, well, why don't we set the case for next Thursday, the 26th?
Okay.
And we'll set you for 1 o'clock as well. I will take your case before I take the contested hearing that I just set. So, Ms. Farkas, I'm going to take Mr. Delgado's case. It should take about 1 or 2 minutes, I would think. I've been, as soon as I say that, I'll be wrong, but.
And I think I might have overpaid on my fines and everything.
Oh, okay. Well, we will certainly sort that out. And you said your probation officer is?
Fowler.
Ms. Fowler, okay. Or is it Mr. or Miss Fowler?
Miss.
Okay. Officer Howell, would you be able to let Officer Fowler know?
Yes, ma'am, I sent her an email.
Oh, thank you so much.
Do you want her here? Or
Well, if she has a position, I'm always interested to hear what the probation officer's position is on a motion like this. And I wouldn't have a problem with her appearing by Zoom as long as Mr. Sprouse is okay with that, if she wasn't going to be here anyway.
I have no objection
Okay.
to using technology.
Thank you. So if that makes it easier for Officer Fowler to weigh in, then I'm okay with that. Just somebody will have to let me know to make sure I got Zoom going. Okay? There should be some papers up there, sir, where you can fill in your next court date if you want to write that down, and that way you'll be sure not to forget it.
The 26th at 1 o'clock?
Yes, sir. I don't know which courtroom I'll be in, but somewhere in the building. Just come find me. I'm Judge Clark, and I will see you June 26th at 1 o'clock. By then, Mr. Sprouse will have a chance to reach out and make the calls that he needs to make. We'll have, hopefully we'll have Officer Fowler be able to be with us and weigh in with her recommendation, and then we will hear your motion and take care of it.
All
Thank
right.
you, sir, very much
Thank
for your
you.
patience today. All right, and Mr. Dubois is next.
Yes, Your Honor. I have
Yes, 25 CF 67 and 24 CF 174. Good afternoon, sir.
Yes, ma'am.
If you'll just state your name for me.
Robert DuBois.
DuBois, thank you, sir. So we're here on your motion to withdraw your plea, and let me hear from Ms. Farkas first.
Thank you, Your Honor. I requested the court smart recording from the day in which Mr. DuBois took the plea. I have it queued up, I think correctly, so we can listen if you'd like. On the record, I paused, Your Honor, as you were reading out the plea agreement. The issue I believe that Mr. DuBois has raised is that in his plea agreement, which in the filed copy you see, I had made a typographical error. I was on autopilot, and 2 of the counts I wrote concurrent on all counts and cases, and in the third one I wrote concurrent and coterminous. In the court smart, which I'm happy to play, I've got the timestamps. You hear me say, excuse me, Your Honor, I have to pause you. I added a word that's an important word and shouldn't be there. Unfortunately, coterminous was never part of the plea agreement that the state and the defense worked out, which is, I believe, kind of obvious from the fact that the first 2 counts, it just says concurrent. So unfortunately, my typographical error, I think, apparently has caused some confusion with Mr. DuBois. But I raised it, I believe I interrupted, Your Honor, to raise it and make sure that it was corrected.
Okay, so,
I didn't come here to withdraw my plea, Your Honor. I just came here under the understanding that I thought it was going to get corrected. I understood that it was concurrent, coterminous, it's like coterminous in all counts and cases. You know, I signed it, we went through everything together. You asked me for my signature if I understood it, then you accepted my plea. And then afterward, I guess she realized whatever she realized, but I didn't. You see where I'm going with that?
you were there.
Yeah.
I mean, you were standing there,
Yeah.
right? Okay.
So I thought,
So, okay.
my understanding when I signed the plea was it was concurrent coterminous.
So let me speak to my staff attorney really quickly. Ms. Foley, if you could just come on up for a sec. Okay, so first of all, I need to ask, is there a conflict that would, I mean, Ms. Farkas, are you in a position to continue representing Mr. Du Bois in this matter?
I don't believe it would be appropriate. I guess I'm not entirely sure. I can only represent to the court what is on the court smart and what, I don't want to betray attorney-client confidence, of course, but the plea agreement that was written up and that he pled to, you read it out, and then he pled to the plea agreement. So I don't know if that creates a conflict, but I suppose if it is in opposition with what Mr. Du Bois is requesting, then I would say that there is a conflict there.
Sir, you're entitled to have counsel represent you. At this point, all I'm able to do today is just figure out if Ms. Farkas will continue to represent you, sir, or do I need to appoint a different attorney?
Are you willing
Because
to
there
just make
could-
it concurrent and coterminous?
Sir,
Are
what
y'all
was that?
willing
I'm
to
sorry.
just make the plea concurrent and coterminous? I'm happy with that. That's all I signed. I have no problem with that.
Sir, I really need to figure out whether you're going to be represented by Ms. Farkas or whether I need to appoint a different attorney before we go forward on any of the details or merits of anything. So,
I'm sorry, Your Honor, that I'm not exactly sure what the answer is.
I trust you.
I really do not want to be put in a position where I feel like I'm arguing against what he wants. That's not ever my job. And that, I think, is unfortunately the position I'm put in.
okay.
So I suppose he could move forward without counsel, and I can provide representations to the court of what transpired that day. But I think that is the best I can do. I don't think that I can represent him if I am making representations that are their opposite of what he wants.
Yes.
Well, I know that I did sign the plea, and you had already accepted it. You asked me if I pled the contest. You said you accepted my plea. You asked me if it was my signature. I said yes. You know, I thought we were done at that point.
I understand your argument, and I'm not trying to be difficult
I
at all.
understand. I'm not trying
but
to either.
I know, I'm just trying to get you
Yeah.
an attorney.
I mean,
And
I
then
just
we-
want Dad wanting to go home to his kids. That's it. I just want to hurry up and get there as soon as possible.
What now, I'm sorry?
Mr. Daddy wanting to go home to his kids as soon as possible.
Understood.
You know, any time that I lose is
So here's what I'm going to do.
very precious.
I understand that. I would like for there to be an attorney to be able to answer your questions or advise you. And I think that there may be, I mean, Ms. Farkas, I think I'm hearing there may be a conflict.
I think there might be in that actually, I don't know if there's a conflict. If I play the court smart and we hear the way that the plea agreement, you taking the plea agreement proceeded, then I don't know that there is a conflict in simply doing that. I wouldn't want to make any additional representations.
Okay. So, Mr. Sprouse.
I'd play the video, the state could play the video so that the defense attorney is not playing evidence that's contrary to Mr. Du Bois's position. It's kind of
Okay.
splitting hairs.
I think I'm going to have to continue the hearing. I think today all I can do, and this is why I have a staff attorney present, I rely on Ms. Foley to help me with post-judgment issues. So, and this is a post,
Maybe we ask the state if he objects to it.
I think he objects, but I'm not gonna, I don't want to speak
That's why
for
I'm
him.
here, is because I object. There was, when this deal was made, there were 2 officers that were in the gallery waiting to put on testimony. The deal was cut. Never, ever in plea negotiations, other than once Ms. Farkas realized that it said coterminous, Was it a part of the dialogue at all?
Okay, so I think I need to resolve the attorney issue, and then I need to reset the case. We've been setting a lot of things next Thursday. I can reset it for next Thursday. So I think I need to probably appoint regional conflict counsel for you, sir.
Yes, ma'am. Thank you, sir.
So that's what I'm going to do. So that way, oh, I know,
I
I'm
just want my kids and we're
understood. I understood. So Ms. Farkas, do you think, unless you feel that there is no conflict between the two of you at all, I mean, sir, do you want Ms. Farkas to remain your attorney, or do you want me to appoint?
She don't feel comfortable with it.
Well,
There's certainly no bad blood between you and
No,
Mr. Du
I
Bois.
love my lawyer. She saved my life once. I mean, I love her to death.
I want to make sure that he gets all his questions answered and that there are not any issues, because there's a pretty big difference between concurrent and coterminous.
Yes.
So I am happy to, as soon as Your Honor appoints conflict counsel, I will, I'll find out who it is and reach out to them and give them information, if I can. That's I think the best that I can do.
okay. I am going to, because there's potential, if there's not already a conflict, there is potential for one. I'm going to relieve the office of the public defender. I'm appointing regional conflict counsel, which is Mr. Harper. He was here a little while ago, but he took care of his cases and then he left. So I'd like to set the case, hopefully Mr. Harper will be available, for next Thursday, so a week from now. And that way, Mr. Harper will hopefully have an opportunity to come and talk to you, get up to speed on things, and be ready.
Explain things a little bit, yeah.
Yeah, he's going to want to talk to you first, and he'll want to read the court file. He'll want to read what you wrote. He'll want to look at the whole case, but hopefully within the next week.
What time next Thursday? I mean, I guess I'll be here anyway, so.
How about if we say 1 o'clock, but it's probably going to be after 1 o'clock, because I know I just set another one at 1, but might be closer to 1:30, but just in the event we don't have pretrial detention hearings and we're running a little bit ahead or on time.
I foresee Ms. Farkas is going to be a witness in this case, correct?
Possibly. So that's why I think I need to appoint
Yes.
a different attorney to represent you and advise you, okay? So June 26th, I'm putting the case down for 1 o'clock. It's probably going to be a little after that, okay? All right. And I'm appointing regional conflict counsel.
So I will come in and I will see the other lawyer and then get another court date, or will that be the court date?
Well, that's the court date. I've got to get an order entered appointing him to notify him that he's now your attorney. And I don't know what his schedule is. I can't vouch for him. I know he doesn't have, next week is my trial week, and all the trials are on a different week and not next week. So he's not in court with me next week, but he may be in the other division. He reports to 2 judges. He has me for circuit, and he has another judge for county court. I don't know what his obligations are next week in county. Ms. Farkas?
Sorry, I was just going to say that I'm going to email Rudy right now to give him a heads up to look out for the appointment, so that he can make sure to see Mr. Du Bois before Thursday.
Okay. I don't know what Mr. Harper's schedule is. So, but I can tell you that he will be notified that he has been appointed to represent you. And I can't tell you when he's going to come see you, because I just don't know. But we will not go forward with any type of hearing until you have had a chance, to your satisfaction, to be able to talk to him. Okay? So.
We're basically just going to figure out.
Yes, he can answer your questions after he looks at everything, but June 26th at 1.
Right. Sorry about the confusion.
Sir, don't apologize. We will sort things out. We'll see where we stand. But I want you to have a lawyer that, that you can talk to and answer your questions, okay?
Yes, ma'am.
All right, I'll see you in a week, okay?
All right, thank you, God bless y'all.
Thank you. So I need to enter an order on that. Did that cover everything on our docket for today? And then some?
I believe it did.
All right. Oh, okay. Thank you all very, very much.
Thank you, Judge.
Have a great rest of your day and have a good weekend. I'll see you next Thursday.